To all who are joining me on this video, this is a webinar that I presented at the West San Gabriel Valley Board of Realtors, my local realty board, in October of 2021. They wanted to know how handling the sale of business opportunities or bulk sales changed during the pandemic years. I am pleased to post this video on my Think Escrow channel. The video is a little longer, but I hope that you will find it educational. Are we there yet? Or is it hurry up and wait? These are the most common gripes in a bulk sale transaction. It's like little kids on a road trip, except we aren't kids, and in some really bad cases, it can sometimes be considered a road trip through hell, especially one that involves additional issues like ABC license transfers and now PPP, EIDL, loan payoffs, and so forth. So I would like to talk to you about the trials, tribulations, and drama of bulk sale transactions during the pandemic. In a good day, bulk sales are never as easy for escrow officers to handle as real property sales. And this is because they are, one, not as common, two, often are for sale by owner transactions and have no real estate brokers involved, three, there's no title insurance to back us up and advise us if something or a document is wrong or right. And four, there are many outside players and factors that are critically important to the transaction for which we cannot do without. I gave a webinar on the bulk sale transaction in November of 2020, but I will take a couple of minutes for those of you who did not attend that session so that I can bring everybody up to speed. Selling businesses and their assets, what we call personal property, is quite different from selling real property. Personal property can be tangible, fixtures and equipment and inventory, things that can be added or subtracted during the course of a transaction. And it also includes intangibles like trade name or goodwill. Real property, on the other hand, is land and structures or whatever else is fixed to the ground and cannot be moved. If you walk down a commercial street, every piece of property that you see on the street can be sold. Also, every store you see on the street can be sold. Donut shops, restaurants, convenience stores, liquor stores, car washes, car dealerships, hotels, and even service businesses like dental offices, massage parlors, to name a few. When sold, all these are part of what we call bulk sales or business opportunity sales. And then we have the combination of real and business sales. And that is the sale of a real property together with a business that is operating within the structure that is sitting on that property. The most important differences between these two types of transactions are as follows. In real property sales, we work in conjunction with a title company who will be ensuring the ownership against all liens and encumbrances that do not belong to the incoming buyer. That is the transaction's safety net. In business opportunity sales, there is no title company that provides title insurance, so there is no safety net. It's all dependent on how savvy and knowledgeable the escrow officer is. So not all escrow officers handle bulk sales. For some, there is just too much risk and it is too different from what they know and practice and in real property sales. Here are some other differences. The handling of a bulk sale is defined specifically in California law through the Uniform Commercial Code, the UCC, and the Business and Professions Code, the BNP. In a real estate transaction, you can have a 5 or 10-day escrow as long as all the conditions are in. In a bulk sale, there's a 12 business days time period that we have to wait before closing according to the UCC code. There is no prelim in a bulk sale. But instead, we are required to do what we call a UCC search of the business name and the seller's names in the office of the Secretary of State and at the county recorder's office. No grant deed is used, but we will use a bill of sale to show transfer of ownership. And this document is not recorded at the county recorder's office. In a real property, normally, whoever is on the title on the last recorded ownership document is the seller. In a bulk sale, there's nothing that is recorded. So we have to rely on various other public documents to make the determination. For instance, the business license, the ABC license, the CDTFA seller's permit. Unfortunately, this can cause quite a bit of confusion, as I will cover later. Landlord approval is important and has been the cause of cancellation of bulk escrows when the landlord feels that the new tenant may not have the financial background to keep the business going. Clients rarely question why an escrow transaction for a real property is needed, but they often wonder why an escrow is needed to transfer a business opportunity. And here are the reasons. First of all, probably the most important reason is that the law requires the seller to give their creditors and vendors notification of the sale so that they can submit their claims for payment. If these creditors are not notified properly, they can and will attach the unpaid claims to the new buyer taking over. So we have to publish the sale of the business in the community papers for a period of 12 business days before the sale can be finalized. This is the prescribed time for creditors and vendors to submit their claims to the escrow. One more important reason, we need to make sure the buyer gets released of all sellers' government tax debts, employee taxes to the Franchise Tax Board, the FTB, employee unemployment taxes to the Employment Development Department, the EDD, and the sales tax that has to be paid to the California Department of Tax and Fee Administration, CDTFA, for the sale of goods. We will be looking for certificates of release of the buyer so that the agencies cannot come back and claim any unpaid seller's taxes from the buyer. And finally, an escrow is needed if there's any kind of liquor license issued by California's Department of Alcohol and Beverage Control, ABC. Today, I am going to talk about these problems that we have seen, not only through the pandemic of 19 months and counting, but also in general, so that we can ask you to help us avoid these problems in the future. So let me share our trials and tribulations. I'm going to break down the problems into 5 most concerning topics: time, incorrect client information, ABC license transfers, those pandemic government loans, and real property plus business. Time is of the essence. Sometimes this is just another phrase, especially during this time period. Our clients may say, go, 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 hurry, hurry, we want to close. But no matter how fast we go, those outside players that we have to deal with have a concept of time that is quite different from ours. Time is not our friend because working from home means delays. Up to now, a lot of government agencies staff are still working from home, whether it is the ABC, the EDD, CDTFA, or the FTB. This means that our requests are now handled via email or online, and the response back is much slower. Other county agencies are now barely open to the public. The county recorder's office just opened up on October 1st, but they don't allow you to go in unless an appointment is made. What is the first thing that has to happen during the start of a bulk sale process? We have to record the notice to creditors. We have to record the notice of intent to transfer a liquor license. It used to be that the search and publication companies could just walk into the county recorder's office and get the recording done. Now, no more. Either you make an appointment to walk in or you sign up with a vendor to do this electronically. Sending the documents in the mail means that you can expect a recording within 3 weeks. If we as an escrow company needed to record something like a tax lien release, we need to find a title company who is willing to record our document as an accommodation. So during the pandemic, we have done the same thing for the notice to creditors and notice of intent. We have sent them to the title company to record as an accommodation to save time. And then we ask the publication company to get the certified copies from the recorder's office once they have been recorded. In the matter of unsecured property taxes or liens, requests for the amount due from the county assessor's office were also delayed because the staff were not in the office. But the biggest problem are the government agencies, especially ABC. For ABC, we understand that many district offices, the licensed investigator may only go into the office once a week during pandemic. So if they are working from home and are organizationally challenged, we may have a problem getting them to check off each individual item that is needed on the license transfer application. The same goes for the client applicant. Time is also an issue. There's a whole slew of documents that needs the client to provide. Even if they hired a third-party license transfer coordinator to help them, some things require the clients themselves to provide or perform. I have one transaction which opened up in October of 2020. It has been 1 year and the license just transferred. 10 months into the transaction, ABC told the license coordinator that fingerprints from the spouse of one of the LLC officers was also needed. The spouse lived out of state. It took a whole month for the spouse to get the fingerprints done in her state. When I checked back, the license coordinator said that the fingerprints were done. But when it was submitted to the DOJ and the FBI, they were rejected because it was not legible. So a new form for a new set of fingerprints had to be sent out to the spouse. So all parties, the client, the license coordinator, and the government agencies all have to be cognizant of the time element and do their best to work to expedite everything. Working from home really caused delays. Incorrect client information. The sources of many headaches. When the escrow officer starts out on a process, we have questions that we ask of the seller client and we ask for copies of their license. If you, as an agent, are putting together a bulk sale transaction, keep in mind what we go through and get answers for the questions that we are going to ask before the transaction is open. It will help your escrow officer open up the transaction much more expeditiously. Getting a copy of the licenses from the government agencies like the city, the county, the CDTFA, and ABC is absolutely essential. Remember, we need to determine who the actual seller is and the correct names. Unlike a real property, incorrect client information from the buyer side causes a lot more confusion and trouble in a business escrow. It is not as easily corrected. It does not just call for an amendment to change the buyer and the grant deed to be redone. If the name of the buyer in a bulk sale changes after documents are redrawn, it is not just re-signing and re-notarizing the bill of sale. It also requires a republishing of the notice to creditors and the notice of intent and resubmission of certificate requests to the EDD, CDTFA, and FTB. These certificates that they issue in the end should reflect the correct buyer's names. Does a seller corporation and officers match what is listed in the filing at the Secretary of State? Or what about does the city and county business license say? Does it match what is listed on the ABC license? Does it match what is listed on the CDTFA license? What about the EDD account? If they do not match, something has to be corrected so that all matches. We have to publish under the correct name. The ABC requires the right officers to sign off on the license transfer, and the CDTFA and EDD have to match our seller to their records. If they don't match, they cannot give us a release. We have one case in which all three did not match. The supposed seller was XYZ Corporation. John and James said that they were the corporate officers, but the records of the Secretary of State did not match that. Now, on the ABC license, the license was under William as an individual, who was a brother who applied for the license way back when. The CDTFA and EDD accounts were issued to John and James under their own individual names. What a mess. So to open escrow correctly for this transaction, this is what the seller had to do. They had to file the correct corporate officer information with the Secretary of State. They had to notify the CDTFA and EDD to change their accounts to the corporation. And they had to do a transfer of the ABC license from William to the corporation. Now, this process involved much of the same background and fingerprint check that the buyer would have had to go through. All these things had to be done before we could open escrow correctly. From time to time, we get sellers whose corporate status was suspended with the Secretary of State. Well, in order to do business in the state of California, and selling a business is doing business, you have to have a valid entity which is registered to do business here. Are you a corporation registered in another state? Well, you will have to be registered here in California too. So the attorneys need to file the registration before escrow is open. No matter if you are the seller or the buyer, we need your corporate operating agreement if you're an LLC, and bylaws if you are a corporation. We need to see who are the corporate officers who should be acting and signing for this corporation. In one of our transactions, one of our corporate sellers had an officer whose name appeared as the corporate secretary on the Secretary of State site. So we needed his signatures on all the paperwork. Apparently, he was a minority shareholder and did not wish to sell. We advised the seller that he will need to figure out what to do with this minority shareholder because he was a corporate officer. The main officer and this minority shareholder had to come to an agreement, and the minority interest was given up, and a change in corporate officers filed with the Secretary of State. ABC license transfer. You need a little drama? Well, here you go. A small restaurant was owned by a corporation. The seller was the president, and this was verified in our search with the Secretary of State. The seller went ahead and signed the ABC 211A form to start the license transfer procedure for the buyer. 2 weeks after this form was turned in to ABC, it was returned to us with a notation that in their files, another person was the president. So this other person had to sign also. When I told my seller, she said that 7 years ago, this person was bought out of the company. Still, he did not give notification to the ABC. So my seller said that she was still on good terms. So she would go and find him so that the form could be signed off. Mind you, the 211A form can be signed in two ways. Either you sign and have your signature notarized and then turn it into ABC, or you could sign it at the ABC's office itself and provide them with your proper identification. So here's where the drama came in. Mr. Kim, the original president, had changed his Korean name to an Americanized name when he became naturalized years ago. He no longer had any identification showing his Korean name. He could not provide picture proof either to a notary public or to the ABC investigator. After 2 weeks of running around trying to find a way out of this mess, our actual seller did find somebody who could notarize, and the form was signed by Mr. Kane. And the form was signed by Mr. Kane and notarized properly. Just this initial process of signing off on the license to begin the transfer, which should have only taken a few days, took an extra month. This is a seller, but incorrect information from the buyer also creates a whole slew of drama and stress. And this is why we insist that a buyer make his decision on the purchase right up front. Will he buy this as an individual or a corporate entity? If a corporate entity is used, has everything been filed? And does he have all the corporate documents? Any delays in setting up the corporate entity will delay the transaction. If ABC is involved and the buyers change, all the parties have to re-sign the notice of intent, and that will have to be re-recorded so that a county recorder's certified copy is provided to the ABC. Of course, all the ABC application paperwork has to be changed, and possibly other paperwork and fingerprints will be needed, like from a spouse. ABC will also need to review the corporate documents. And when this change happens close to closing, yep, there is a little bit of drama. I had a transaction that opened in the middle of February with two individuals as buyers. In the middle of March, the two individuals decided to form an LLC. When we were trying to close by the end of April, the LLC finally got their corporate paperwork together, and lo and behold, after review, ABC found out that one of the persons listed on the application was not actually listed as a manager of the LLC. So we had to change the escrow again to show only one manager. As mentioned previously, every time there is a change, the notice of intent has to be re-recorded and a certified copy provided to ABC. 1 week to get the recording done as an accommodation with a title company, and then another 2 weeks to get a certified copy from the county recorder for the ABC. We were talking 3 changes in that transaction, so about a 9-week loss of time just to get the buyer's name corrected. Of course, all sorts of other drama was going on at the same time. The seller's SBA loan, the buyer's refinance loan for the closing funds. This transaction that was opened in February and was scheduled for closing at the end of April did not close until the beginning of August. So time, incorrect client information, and ABC license transfers. Problems, problems. Let's now talk about those pesky pandemic loans. I call them pesky because all they do is cause trouble and annoyance for us. I am talking about the PPP, the Paycheck Protection Program, and the EIDL, Economic Injury Disaster Loan. Both of these types of government loans are handled by the SBA, and the government responds to help with losses sustained by businesses due to the pandemic. The PPP loan is handled through a bank of the business owner's choice, and the EIDL is given by FEMA, but handled directly with the SBA. Our escrow instructions have been revised to add that the seller will need to provide buyer and escrow with information regarding either of these two loans so that the payoff can be made. We require that the sellers sign under penalty of perjury that there are no such loans or that they have been disclosed. The headache rests on the PPP loan. It does not have to be paid back and can be forgiven as long as the business owner submits the proper documentation needed to show he has used the loan for the payroll. Unfortunately, this loan has no collateral filings, so there's nothing that we see on the UCC search that will point to a PPP loan against the business. We must rely on the seller's honesty and integrity to let us know that the loan has been forgiven. If there is or was a loan, we will have to ask for a letter from his bank that the forgiveness of this loan has been approved. What happens if the PPP loan is not totally forgiven or the process has not been completed and escrow has to close? Well, the bank handling the loan may require sufficient funds to be set aside in escrow or deposited with the bank pending finalization of the forgiveness process. This is something that the escrow officer has to discuss with the seller and his banker and find out what their requirements are going to be. Around September of 2020, I closed a small restaurant transaction, and 2 weeks after the closing, the buyer received a letter at the business addressed to the seller from the SBA, which talked about the PPP loan. Now, this was my first encounter with this loan. The buyer was so upset that we did not take care of it. But as I told the buyer, unless the seller had informed us, there was no way we would have known. There is a website that listed recipients of the loan, but it only lists those loans over a certain amount. This was a small loan, but nevertheless, the buyer would have been stuck with it if the loan was not paid off. The seller did pay it off, but the buyer understandably remained very upset and distrustful of this seller. There were 2 rounds for the PPP loan. One was April to August in 2020, and the other was January to July of 2021. If I am doing a transaction now, hopefully the forgiveness for the first round has been already issued, and hopefully the business owner has no need for the second round. But the forgiveness for the second round could be still in process if they had applied for one. So we have to watch for that. The EIDL loan, on the other hand, is an SBA loan secured on the assets of the business and payments are required. If the loan is over $25,000, a UCC financing statement will be filed and would be found when the UCC search report was ordered. This loan is handled like any other regular payoff of a loan, complete with a payoff statement and a requirement for a release or a UCC termination. The only difference is that getting in touch with the SBA to get us this loan payoff could be time-consuming. First of all, SBA does not talk to anyone but the borrower, unless specific instructions are given by the borrower that allows the SBA to talk to escrow. So the best way to insert ourselves into the conversation is to get escrow, SBA, and seller on a conference call to get the authorization. I was asked to open a transaction on a restaurant around July of 2021. The buyer wanted to rush to closing, but the restaurant had a liquor license, and I told them it would take at least 90 days or more to get the license transferred and escrow closed. The buyer couldn't wait. They wanted to apply for the PPP loan before the second round program ended. Now, if I understand this correctly, the loan is to help businesses keep the payroll going so people would not be laid off and the business could survive. How would this work for a business that was just bought and had no payroll data of its own? Well, needless to say, the buyer did not like my answer that I could not close escrow without the liquor license transferred, so I didn't have to deal with the transaction. And maybe it was a good thing because that could have been a very stressful one. I did open a pizza fast food transaction and it was smooth all the way until I got to the UCC search report. On it was a loan in favor of the SBA. Obviously, looking at the SBA loan, I knew this was an EIDL loan. I presented the report to the seller and advised him that these loans had to be paid. The transaction came to a stop. The EIDL loan was for triple the value of the restaurant sales price. The seller did not realize this loan was going to be filed against the business. He said, "This was cheap money at minimal interest. Why should I pay it off?" Well, he said he got it for the corporation and not the business. However, the corporation name and the business name were the same. I pointed out that the filing mentioned that it was against the assets of the business, including the fixtures and equipment and so forth. He would have to pay it off, or the seller or the buyer would be burdened with it. So that was the end of that transaction. On the other hand, I had another transaction in which the seller had an EIDL loan that he was not going to pay off. Instead, he wanted to transfer this loan to his other ongoing business in another state, and SBA agreed to it. It took a few months, but they signed the necessary paperwork, and after much follow-up from me, the SBA contact person finally got their legal department to get me a UCC termination on our restaurant. Unfortunately, my pizza seller had no other business that he could move that loan to, so he would have had to pay it off. Real property plus business opportunity. Double trouble. Here are some of the questions that we ask. What is the breakdown of the sales price for each? Are the buyers and sellers for each transaction the same? Do we need to open two transactions? It is preferable. If we do open two transactions, hopefully it states that they will close concurrently. Is the buyer getting a loan? Is it on one transaction or both? Is there a liquor license in the business transaction? What are other conditions that are special to these transactions? Stress comes when you have a real property purchase, which has to close concurrently with the purchase of the business on the property. The business has a hard liquor license. The buyer is getting an SBA loan to cover both purchases. And the buyer is using the real property as part of his 1031 tax deferred exchange, which had a time limit. What doesn't kill you will make you stronger. And this is my final story for today. Each transaction in itself was not difficult, but circumstances conspired to make it difficult and provide for an educational lesson that we can teach today. Although both transactions had the same seller and buyer entity and could have been opened as one transaction, I elected at the opening of escrow to do two separate transactions because I have found out that you just never know what the future holds. So separating them is best, just in case. Both transactions had to close concurrently, and this verbiage was added to both. The business was a mini market, and the liquor license was an off-site hard liquor license. So I felt the qualification process might be taking a little longer. I advised them of the 90 days minimum to get the license transferred. Then the buyer, of course, was getting one SBA loan to cover both purchases. And it seemed like the lender understood the process of what happens in a bulk sale with a liquor license. So far, so good. We are waiting for the SBA lender, and the SBA lender was waiting for the buyer to complete the license application so that the license could transfer. 4.5 months into the escrows, not only had the license not been transferred yet, the buyer calls up and advises me that he has to close escrow within the next 15 days because the real property portion was designated as the upleg of his 1031 exchange, and it was an exchange for $1 million. His 180 days was almost up. He only had 2 more weeks to close, or his exchange would have been invalidated. Oh my goodness. Just shoot me and put me out of my misery. Now it became a mad scramble to figure out what to do. Here are the issues again. The real property had to close for the exchange, but it is 1, concurrent with the closing of the business transaction. 2, the business could not close without getting the authorization from ABC. And 3, the buyer's one SBA loan had to be secured on both the real property and the business at the same time. Yes, it is a good thing that I opened 2 escrows so I could close the real property once the parties eliminated the concurrent condition. And after much negotiation, the SBA lender agreed to fund only the loan on the real property, with the caveat that everything had to be ready to go for the bulk sale closing, and that closing was only subject to receipt from ABC of authorization to close. Okay, but I told this lender I was not going to be willing to stick out my neck and request the authorization to close if I did not get an unconditional guarantee from this lender that the business loan would fund immediately upon my receipt of the ABC authorization to close. So chicken meet egg, egg meet chicken. After much discussion, the lender agreed to give me the guarantee letter. The final condition was that the seller and the buyer had to work out an agreement for after closing of the real property, because then the seller would become the tenant and have to pay rent to the buyer, who would then become the landlord. Well, docs were drawn, all paperwork in both escrows were completed. The exchange company wired all the funds to close the escrow for the real estate. The lender funded the loan on the real property, and the buyer deposited all his down payment and signed everything for the business escrow. The day we closed the escrow on the real property, the lender gave me the unconditional guarantee letter that they were committed to fund the business loan. And with that, I overnighted the request for license transfer to ABC. Meanwhile, outside of escrow, buyer and seller signed a lease back agreement. The lease payment was going to start 1 month after closing of the real property, and the rent amount would be minimal. All's well that ends well. The business transaction closed about 3 weeks after the real property. The hardest part about these 2 transactions was that no one, not the buyer, the seller, the real estate agents, the lender, or the loan broker, really understood the process and issues involved in a business opportunity sale that had an ABC license. I wrote numerous emails and answered so many phone calls to explain the process again and again and advise them on what I could or could not do. They didn't understand the constraints that we had, and that time was not something that we could actually control. What a crazy industry this can be. So here we are, the trials, the tribulations of handling bulk sales at any time, but particularly through the pandemic years. Time, incorrect client information, ABC license transfer issues, and the brand new matter of pandemic loans. These have surely created a lot of drama in our lives. My contact information is in this last slide. Thank you very much. Please subscribe to my YouTube channel, Think Escrow, and look for new videos that I post on my channel from time to time. This is Juliana too from Viva Escrow, and I appreciate your time in watching this video.